Ready? Start. The present application has been filed on behalf of the plaintiff under Order 11, Rule 5 of the Code of Civil Procedure, 1908, under bracket CPC as applicable to the commercial suits under the Commercial Courts Act, 2015 for placing on record additional documents. Stop para. Reply has been filed on behalf of the defendants opposing the present application. Stop. Rejoinder thereto, has been filed on behalf of the plaintiff. Stop para. It is the case of the plaintiff that the aforesaid additional documents were filed by the plaintiff on 17th October, 2017 on the same date as the replication. Stop. Counsel for the plaintiff submits that the filing of the aforesaid documents was necessitated on account of the statement made on behalf of the defendants, as noted in the order dated 26th September, 2017, that the defendant number 1 was not in existence at the time of the filing of the present suit, and some of the additional documents sought to be filed are to demonstrate that the defendant number 1 was in existence at the time of filing of the present suit. Stop para. Yet, another justification given on behalf of the plaintiff for filing additional documents is to demonstrate the contrary stance taken by the defendants in their written statements and in the replies to the examination reports of the registry. Stop. It is stated that in the written statements, the defendants have taken a stand that the trademarks taglines, which are the subject matter of the present suit, are descriptive and generic in nature. Stop. However, in various replies to the examination reports of the registry, the defendants have taken a contrary stand. Stop. Therefore, it is necessary to place the aforesaid documents on record. Stop. Reliance is placed on Order 11 Rule 1 C second of the CPC. Stop para. Per contra, senior counsel appearing on behalf of the defendants submits that since the defendant number 1 has already been deleted from the array of parties, the documents with regard to the defendant number 1 are no longer relevant in the present suit. Stop. It is further submitted that there is no contradiction in the stand taken by the defendants before the trademark registry and the written statement filed in the present suit. Stop. It is also contended that the documents now sought to be filed were in the power, possession, control, and custody of the plaintiff at the time of filing of the present suit and therefore, ought to have been filed along with the suit. Stop. Para. Reliance is being placed on the judgment of the Supreme Court in Sudhir Kumar versus Vinay Kumar, 2021 SCC online SC 734 and the judgment of a coordinated bench of this court in Nitin Gupta versus Tax Maco Infrastructure and Holding Limited, 2019 SCC online DEL 8367. Stop. Para. I have heard the counsel for the parties. Stop para. A perusal of the additional documents sought to be placed on record by the plaintiff would show that the said documents are the examination reports of the registry and the responses thereto by the defendants. Stop. All the aforesaid documents pertains to the defendants. Stop. Attention of the court has been drawn by the counsel for the plaintiff to paragraph 18 of the written statement filed by the defendant number 2, where a specific stand has been taken by the defendants that the trademark taglines, which are the subject matter of the present suit, are descriptive in nature. Stop. The aforesaid contention has been rebutted by the plaintiff in its replication. Stop. In order to meet the aforesaid contention of the defendants, the plaintiff seeks to place on record the aforesaid documents to show that in their replies to the examination reports, the defendants have claimed the trademark to be distinctive. Stop. The aforesaid documents are covered within the ambit of sub-rule 1 under bracket C under bracket second of the rule 1 of order 11 of the CPC, in terms of which the plaintiff would be entitled to file the documents in response to a case set up by the defendants after filing of the plaint. Stop. Therefore, there is no merit in the submission of the defendants that the aforesaid documents were available in public domain and could have been filed along with the plaint. Stop. Even if the said documents were available in public domain at the time of filing of the suit, the need for filing the aforesaid documents arose only on account of a stand taken by the defendants in the written statement. Stop para. insofar as the objection of the defendants that the documents in respect of the defendant number 1 are not relevant, as the defendant number 1 has been deleted from the array of the parties, it is contention of the plaintiff that despite the defendants claiming that the defendant number 1 was not in existence, certain replies were filed on behalf of the defendant number 1 before the trademark registry, therefore, the aforesaid documents are relevant for determining whether an incorrect stand has been taken by the defendant or not. Para. In Sudhir Kumar Supra, relied upon by the defendants, the Supreme Court was dealing with the provisions of Order 11, Rule 1 under bracket 4, read with Order 11, Rule 1 under bracket 5 of the CPC in respect of filing additional documents after filing of the plaint in case of urgent listings. It was further observed that the rigor of establishing reasonable cause for non-disclosure of the documents along with the plaint may not arise in cases where additional documents are discovered subsequent to filing of the plaint. The aforesaid judgment does not in any manner curtail the power of the court to permit additional documents to be taken on court if a party gives sufficient cause for not filing the said documents along with the plaint.